Deputy Registrar, can you please commence the proceedings?
Yes, good morning, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Guyana, hearing of application in GYACR number 2 of 2023 between Sherwyn Harte, Deon Greenidge, and the state. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, Counsel.
Mr. Justice Witt.
Good morning, Counsel.
And Mr. Justice Anderson.
Good morning, Counsel.
May we have the appearances, please? Thank you.
If it pleases your honors, my name is Douglas Mendez. I am appearing with Mr. Joe Middleton and Mr. Nigel Hughes on behalf of the applicants. Mr. Middleton is on the screen, but I saw from the email that Mr. Hughes was trying to join. I don't know if he's been successful as yet.
Yes, thank you. And for the respondents?
Good morning, Your Honors. My name is Deon McCammon. I appear for the respondent, please, with Ms. Tishani Lake. And Ms.
Yes, thank you.
You also pleases you. Nigel Hawk appearing with Ms. Loretta Noel, Ms. Rihanna Clark, and we're led by the Honorable Attorney General, Mr. Margaret Anand, Senior Counsel, who apologizes for his absence this morning. Obliged.
Yes, thank you. Mr. Mendez, are you ready to begin?
Yes, Your Honor. You will have seen our written submissions, and I believe you will have seen the email from the respondents indicating that they were not objecting to the application for leave. The application is in, you might say, two parts. One is an application on behalf of the second appellant or applicant, and he is appealing against his conviction, whereas both appellants are appealing against sentence. And that appeal against sentence also has two dimensions, you might say. The first is that they ask the court to rule that the death penalty is in of itself contrary to the Constitution of Guyana, and therefore ought not to be one of the available punishments that a court would consider. And in any event, they say that to the extent that the Court of Appeal acted on the basis that the death penalty in their cases was imposed mandatorily when the law at the time was that it ought to have been in their discretion, and then proceeded to sentence the appellants. The respectful submission is that that was done contrary to the rules of natural justice and the protection of the law, in that the normal process that would apply in those circumstances simply was not followed. The question of resentencing just simply did not come up, and there was no opportunity to be heard. As far as the application in relation to conviction is concerned, my learned friend Mr. Hughes will deal with that aspect of the application, and he is online now.
Yes.
My lord, my profuse apologies. I joined the wrong link, and I'm very sorry for having caused any disruption to the hearing.
Yeah. That's okay.
In relation to the appeal against conviction, only one of the appellants is pursuing that, and essentially this appeal is based on the following principle, Your Honor.
Just a second. So the appeal is in two parts: the one on the death penalty, the one on conviction. Which one is going to go first? The one on the conviction?
Yes, Your Honor. The one on conviction, I don't believe will consume much time at all. And essentially, shall I go ahead, Your Honor?
Yes, please.
If I may ask before you go ahead, I thought Mr. Douglas Mendez said earlier that the respondent was not objecting to the grant of special leave, and it might be an opportune point to ascertain where the non-objection lies? Is it to both grounds of or both intended grounds of appeal, or is it simply to one or the other grounds of appeal that the respondent does not object? Somebody from the DPP's office could supply an answer.
Ms. McCallum?
Yes, please, Your Honor. The non-objection is in relation to the sentence, please, the constitutional point, please, with the death penalty.
So, may I take it from that then that you are objecting to what Mr. Hughes is about to present to us?
Yes, please.
As grounds for grant of special leave?
Yes, please, Your Honor.
Thank you.
Okay. Yes, proceed, Mr. Hughes.
Thank you very much. The case against the conviction of Deon Greenidge was based on a confession. In that confession, he indicates very clearly, which was accepted by the Honours of the Court of Appeal, articulated by Her Honour Madam Justice Gregory, that he only became aware of the intention of the third name accused, who was the leader of the Guyana Defense Force Group, of the intention of the murder after he had forced, this is the captain of the group, had forced and pushed the deceased off the vessel. He said it was at that point he was commanded by the captain to go to the boxes which were on the vessel, open them to examine their contents, and that's when he became aware of it. The Honours of the Court of Appeal accepted that was when he became aware of it, but somehow went on to say the fact that he decided after the fact to participate in the activities of the distribution of the proceeds of the robbery meant then that somehow that could attribute to him an intention to participate or be a participant in the murder. It is our respectful submission, in a word, Your Honor, that if anything, he was an accessory after the fact, which could render him liable, but those directions would have had to have been given to the jury, which they were not, and I believe that is, sorry, Your Honor.
Is it liable, Mr. Hughes? Is it liable to what penalty?
The penalty for accessory after the fact is the same as the penalty of if he was convicted as a principal. But the legal principles applicable to accessory after the fact are completely different. And of course, Your Honor, if he was convicted as an accessory after the fact, there were other mitigatory factors that he would have been afforded an opportunity, or ought to have been afforded an opportunity to present to the court, which he was not. And I think it is evident that the Court of Appeal, subject to Your Honor's having a different opinion, did not hold a sentencing hearing and did not effectively address the issue of sentencing. So I wouldn't bother to repeat what has gone before, but that is the essence, the core essence of the basis upon which we are respectfully submitting that Mr. Harte, who is the most junior officer, sorry, Your Honor.
Is it Mr. Harte or Greenidge?
Sorry, Mr. Greenidge, not Mr. Harte, sorry, Mr. Greenidge. Basically, the confession only became aware of the murder after the murder in the confession. And consequently,
if I may, and you see, this is where there is an issue about a jury's decision in circumstances where juries are not required to set out in writing what they believed, what they didn't believe, what were the reasons for their decision. The issue is not so much, to put it in the form of a question, is the issue what the Court of Appeal accepted or what the jury accepted. So that when you say that the Court of Appeal accepted that the only evidence is to be found in the caution statement, if there were surrounding circumstances, how do we know that the jury did not also consider those surrounding circumstances?
Well, I would seek to respond to that this way. No assistance was provided to the jury by the trial judge in regard to the participation of the accused after the fact. That just did not occur, and there was no direction to the jury in relation to the issue that the only evidence that was before the court was in the confession and the context in which that should be interpreted. So, in a word, Your Honor, the jury did not receive any assistance or guidance on whether or not he was a participant before the act was committed, whether he assisted, aided, participated, was party to. There was no guidance in that relation. The facts were left
entirely to the jury, but they were men and women of common sense, we have to assume. And was there any evidence that when the money was being shared up, Mr. Graham said, no, I don't want any part of this, that's blood money, and that the money was forced on him?
There's no evidence, at least as far as the record is concerned, that he either rejected or was forced by a superior officer to accept it. But my only, and I wouldn't presume to anticipate, Your Honor, but my only response to that would be that the fact, even if it were not forced on him and he decided to participate afterwards, I think that would change the character in terms of criminal liability of his participation.
Mr. Hughes, I saw that all three accused at the time gave a caution statement, correct?
Yes.
Were all those statements read during the trial? Allowed?
All statements were admitted into evidence, yes.
Yes, so the jury heard all three?
The jury would have heard all three.
Yes, and is it that the other two, in the other two caution statements, the accused kind of admitted that there was a plan to kill Mr. Randas?
I can say with certainty one of the other accused said that there was a plan.
Yes.
The accused that I represent, Mr. Greenidge, did not say that there was a plan at all.
No, I know that. But did the trial judge point out that the jury could not use those other statements to come to the final conclusion?
My response to that, Your Honor, would be very likely. In my respectful submission, that would have been a particularly, that would have required a pretty robust and strong direction, and I dare say it was light at best in that regard.
Okay, thank you.
Mr. Hughes, I'm a little concerned about your characterization of the opinion of Justice Deon Greenidge. I think in the learned Justice of Appeals judgment, she indicated that the prosecution's case rested on the contents of caution statements given to the police and circumstantial evidence drawn from eyewitness testimony. Would you agree that she said that?
She did say that, Your Honor.
All right. I believe as well she went on to indicate the nature of the eyewitness testimony. Would you agree?
The eyewitness' testimony? You mean the acts after he was arrested and his relatives coming to the police station and
Well, no. There was some suggestion, for example, that all three accused persons had been seen 1 week before speaking to Mr. Ramdas.
Yes,
Is that something that is right?
Yeah, but she did refer to that.
And that when he went into the boat, went or was coerced, whichever it was, into the boat, his complexion changed. His facial expression changed.
That aspect of it, I might have escaped me on. The complexion changing, I wouldn't seek to challenge if Your Honor has it before you. But that aspect, certainly did not engage much attention by me either in the Court of Appeal or here.
So once you said then that up until this point, the point of the, I presume, opening of the box and discovering the $17 million, there was no evidence. But you not go on afterwards to speak about inferences that could be drawn from the conduct. If you start at the conduct of opening the boxes, seeing the money, and then, as the President indicated, allowing for the division of the funds into 3 equal parts, apparently. Would it be permissible for the jury to draw inferences from that event?
Well, Your Honor, I would say permissible, but again, the context is very risky because, of course, in the absence of any other evidence, Her Honor Justice Gregory relied a lot on what took place afterwards, where the money was found, and all the events that were post the forcing of the deceased off the edge of the boat. The evidence in relation to how he came on the boat and it was not unusual, all of that was put to the jury. Now, and specifically in relation to the contention that inference can be drawn, Your Honor, I would only hasten to respond to say that equally pernicious, if I could use that word, to the balanced fairness in the trial is that from that inference you could draw participation when in effect there was none, and it could only be that he, at that point, formed the intention, either formed the intention or whether he was coerced.
Sorry. No, please go ahead.
No, please, after you. I was just going to say that would be, that particular risk would have to be brought specifically to the attention of the jury and not left merely as part of the circumstantial evidence. Because where there are 2 inferences, one in favor of the accused and one against, at least that aspect ought properly to have been brought to the jury in the summing up. So even though Her Honor said, yes, you can draw this inference, I think it should have been accompanied by that warning.
Would you agree that there's a special obligation on members of the security forces, perhaps, who are sworn to protect the people of Guyana and to maintain order, that in the circumstances that we're discussing, your client had any responsibility over and above the ordinary citizen to disassociate, as the President indicated himself, from what was going on? Do you think there's any special responsibility on your client in this regard?
I think, and you do use the word responsibility, and I will address it, but I would like to introduce the use of the word status. And I certainly agree that as a member of the military, his status as a junior officer or an officer at all would have been more than an ordinary citizen, but that would be more appropriately visited in sentencing. Because, of course, the obligation as a military person sworn to protect would, I think, in the event of a conviction, work against him. Rather, at the point where the question of criminal intent or criminal liability exists, only insofar as the rules of the military spoke to this specific fact, would I say he had a special obligation. As in the sense of legal, not moral or anything else. I mean, certainly morally the actions are not defensible, but that's not the area at which I'm seeking to engage.
Well, I would like to come to the issue of martial law or court martialing, if that's the appropriate expression. But just to stay a bit longer on this issue of any enhanced responsibility, if you agree that as a member of the armed forces of the country, as a member of the security force of the country, he stands in a different position to that of the ordinary citizen. Does that not help us with the inference to the extent that if he stands in this enhanced position to protect Mr. Ramdas, and he doesn't do so, but instead he shares in the spoils of the man's murder. Does that help us at all with the question of the inference?
Well, I'm happy to engage that. So we're talking about two specifically different points of entry. Ramdas was forced off the edge of the boat when he didn't have an opportunity to, well, he was not aware of the intention of the captain and didn't have an opportunity to save it. That's one point. The point at which he decides to participate in the proceeds of the sale of the robbery stroke, with the murder stroke robbery, is a separate point. At that point, there was no opportunity to save Ramdas because sadly he had been gone. We lost him from the time he'd gone over the edge.
But did you not see him being pushed over the edge?
No, the confession statement, which is all I have to go on, Your Honor, indicates that he only became aware that he was going to be pushed off the edge when he was pushed off the edge by the captain.
Yeah, so he was aware when he was pushed off the edge by the captain.
Yeah, but at that point, Your Honor, I'm not sure what he could properly have done from a legal, even in his enhanced military position. I suppose throw a lifeline to him, throw a lifeline to him.
Yes.
And again, this is an area of great speculation because we don't know what the reaction of the captain would have been, because the captain clearly who would have committed this murder would then have been in a position where he perhaps would know that if anything was done that could possibly result in him being personally exposed, may have taken some action against the junior officer. And it's highly speculative. So at that point, Your Honor, even if he had an enhanced responsibility, the opportunity for action was merely, I suppose, to attempt to rescue him. Now, I'm not sure that his failure to attempt to rescue him can be elevated to the level where the requisite mens rea for murder was satisfied. I certainly think that may raise other legal issues, but I don't think, specifically in relation to the issue of mens rea, that his failure to intervene as a person with expanded obligations as a member of the military would rise to that required for murder. And even if it did, I think that would be an issue which the jury ought to have received some assistance on.
Yes, thank you. And one last thing on this. The issue of court-martialing, is that relevant at all? Was that ever relevant to what occurred?
Your Honor, I really would, I don't think I possessed of enough appropriate knowledge on that to say why that was not pursued or whether that would have been the preferred course of action. And anything I say now would really be just on basic legal principles, but not on any particular knowledge upon which I can assist the court or attempt to assist the court.
Appreciate it. Thank you, Mr. Hughes.
Yes, one last thing, Mr. Hughes. The caution statement of Greenidge, it's not in the record this file, is it?
Oh, there.
I have not seen it.
Maybe
Callan.
I was working on the Court of Appeal record because we took so long to get the other decision. I do apologize if it's not there. I'm not in a position at the moment to confirm, and may I be allowed to convey its existence or lack thereof to your registrar afterwards.
We certainly would like to see it. Yes.
Thank you very much, Your Honor.
Mr. Hughes, suppose we would agree with you. What would you want the court to do? Send it back to deal with it ourselves, or send it back to the Court of Appeal or to a trial judge? What is it that you would want us to do?
Well, Your Honor, if you were persuaded in that regard, I think sending it back to the Court of Appeal would not exist as an option because, of course, if the conviction is vacated, the question would be whether or not the passage of time is such, along with the other attendant factors, that it ought not to go back or whether it goes back to trial. But I don't think the Court of Appeal would be the location if you were persuaded in conviction. In relation to whether it should go back to the High Court for a trial before the jury, naturally I would seek to persuade you that the passage of time and the difficulties attendant to that ought to result in it being set aside.
Would you agree that another option would be that even if we were to agree with you, looking at the thing in the round, we could say that he seems subject to the reading of the witness, or portion statement, I should say, and to some extent, based on what you have said, that he will be guilty of, at the very least, being an accessory after the fact. And since the penalty for that offense is the same as being a principal, and given the 18 years that
your show is for a little bit, Justice Andy.
yeah. Thank you, President. And given the 18 years that he got before he can be considered for parole, and in the round, there's no serious miscarriage of justice. Is that not another option that we could take, Mr. Hughes?
Certainly, Ron, it would be an option, but I would seek to argue that he at least be permitted to mitigate in relation to any conviction as accessory after the fact. I don't think the issue is, respectfully, is penalty. The issue would be the question of circumstances and issues, for example, junior officer being commanded, etc., would, I hope, engage the attention of a court that was about to impose a sentence. So even though the penalty to which he was exposed may be the same, I think the mitigatory factors which ought to have attracted the attention of a court, specifically, and in this case it would be Your Honor's, would perhaps be, would I would respectfully submit be considered by the court before saying that the fact of the sentence or the extent of the liability to sentence is the same.
Yes. I understand. Of course, we want to get to that point if we agree with you that the inference can be drawn that he was a party.
Of course. I was just responding to Your Honor.
Yes, I follow. Yes. So 18 years for being an accessory after the fact to murder, with what we know, you think would be excessive?
Yes, Your Honor, because particularly in the circumstances of this case, I mean, I'm sure if I were to persuade you on expanded submissions, I would develop the point. But I certainly think some junior officer who sees what a commanding officer has done, whether coerced or as a result of lack of appropriate will or commitment to the military rules, decides to participate, whether that can be, whether that should be treated with the same measure and severity as if he were a principal who had planned this. I would hope to persuade Your Honors that it would be a different set of circumstances.
So in that case, you would want us to do the resentencing. Is that correct?
If Your Honors were unpersuaded on conviction and were of the view that there was sufficient evidence upon which a jury could arrive at the fact that he was an accessory after the fact, putting all those legal issues aside, assuming that the court were so persuaded, I would believe at this point, Your Honor, this far after the event, this would be the only appropriate court to address that issue of sentence. Subject, of course, to what Your Honors have indicated, the probation reports and all the other reports that would have to come before you to consider that sentence.
Thank you.
Okay, thank you very much, Mr. Hughes. I take it that's your submissions on the conviction element?
They are, Your Honor.
Yes, okay. Mr. Mendez?
Thank you very much, Your Honors. If I may just add to what my little friend said, just to emphasize that if we do get to the stage of sentencing and Your Honors decide to take on that task, then we would have to put the necessary evidence before you, which would make the sentencing process a complete one. So there would be just that rider. On the question of sentence itself, if I may deal with the question of the constitutionality of the death penalty, of course we rely on the written submissions. But if I may say that albeit we are on an application for leave to appeal, will this not coming to the court via a criminal appeal before the Court of Appeal of Guyana, then there would have been a right of appeal to this court because it is raising an issue of breach of constitutional rights. So that is certainly a matter that the court ought to consider.
Mr. Mendes, if the death penalty would have been maintained, then I can follow you. But in this case, there was no death penalty imposed in the end. So how can we then deal with the constitutionality of a punishment, of a sentence that has not been imposed? That is something that troubles me.
Because, Your Honors, as this court has ruled in the past, in engaging in a sentencing exercise, the court ought to remind itself of the options that are available. What is the most severe penalty and what is the least severe penalty, in order to make a determination as to what is the appropriate sentence. If the death penalty is available, then, and as the Court of Appeal has held, it would be discretionary, then first of all, consideration would have to be given as to whether the death penalty should be imposed. Our respectful submission would be that that ought not to be on the table at all. And therefore, the court will have to first make the determination as to whether it is on the table. And that raises constitutional questions. The point that I'm making is that because it raises a constitutional question, the court has to consider that the applicants would have had a right of appeal to the CCJ to raise that constitutional issue if it had come before the court in a different fashion. But because it is coming as in the course of a criminal appeal, then we have to apply to the court for, or the decision was taken to roll up all of the issues in the application for leave, because of course we had to apply for leave in relation to the conviction of one of the appellants, and then we'd have to apply for leave in relation to the sentence itself if we left out of consideration the constitutional issues. So I'm just making that point, that the constitutional issue is, albeit a separate point, but nevertheless it is integral to the sentencing exercise that the court will have to take into account. So
I suspect my brother Justice Smith might not be finished with his questions, but that's sort of interrupting Mr. Mendes. But I just wanted to ask you this sort of threshold question. You say that this matter raises an issue of constitutional interpretation, if you will. Who decides whether in fact there is an issue of constitutional interpretation that arises? Is it the court? Is it us, in effect, that decides whether this is an issue of constitutional interpretation that arises? And if that is the case, could we find that, maybe for the reasons behind the questions raised by Justice Smith, that there is no constitutional question that arises? And that there's no appeal as a
to answer your question directly, yes, it is this court. I'm terribly sorry, Your Honor. I don't know if you were hearing that, but somehow other devices are connected to the computer, and sometimes it makes unwelcome noises. Yes, it is this court that will have to determine whether a question concerning either an interpretation of the Constitution or an issue concerning constitutional rights have arisen. Ultimately, because you will have to determine whether there is a right of appeal in the course of determining whether you should grant leave. The fact of the matter is that the question of the constitutionality of the death penalty was raised in the Court of Appeal. There was an argument made that by the Attorney General that the Court of Appeal had no jurisdiction to consider it And the Court of Appeal rejected that and held that it did have jurisdiction to consider it, but went on to say that the death penalty was saved law. So that an issue of constitutional interpretation stroke breach of constitutional rights was considered by the Court of Appeal. And ordinarily, there is a right of appeal against that determination. So you have on the books, as it were, at the moment, a determination by the Court of Appeal on that constitutional issue. And it is this court which has the final say on such issues. So that, to answer your question, yes, it is for this court to make that determination, but we respectfully submit that the answer has to be that there is a constitutional issue raised in the case, and there is a determination by the Court of Appeal on a constitutional issue.
I am not following.
There's a right of appeal.
Sorry, with respect, I'm not following. Why do you say we have to come to that conclusion? If the point is that the Court of Appeal took the death penalty off the table, as I suspect my brother Justice was getting at, as maybe said as much. So your clients were not exposed in the Court of Appeal to the imposition of the death penalty. Why do you say that we will have to then consider the constitutionality of the death penalty?
Well, Your Honor, they took the death penalty off the table. I should say they took the mandatory death penalty off the table, but they held that the death penalty was still discretionary.
Sorry, not interrupt you, sorry, but did they not also take the discretionary death penalty off the table in this case?
They did so, yes.
Yes. So in other words, there was no risk of your clients being exposed to that penalty, was there? Once they're taken it off the table.
Well, there was also always a risk until it was taken off the table.
But it was.
But the point is that the court made a determination as a matter of law that it was on the table. It then gave consideration as to whether it was an option that appropriate to this case, and they rejected that. And then it went on to engage in the sentencing exercise on that basis. So I guess that, Your Honor, the question that you are raising, if I may translate it, is whether the question of the death penalty is academic. And in that regard, of course, this court has given guidance as to when an issue of this sort is to be considered academic. And what you do consider is whether this is an issue that is likely to arise again. Now, the fact of the matter is that having regard to the determination of the Court of Appeal that the death penalty is not per se is not unconstitutional, then the very next conviction for murder that occurs, the High Court will be required to consider whether the death penalty is appropriate in that particular case. So ultimately the issue will come before the Court of Appeal. Sorry, this court, because the Court of Appeal has already determined that the death penalty per se is not unconstitutional. So that one of the factors that the court considers in determining whether it is academic is whether it is an issue that is likely to arise again. And respectfully submit that it is likely to arise, but only at this level, because the Court of Appeal has now determined that the death penalty is not unconstitutional. We respectfully submit as well that if this court makes the determination that the sentencing process was flawed, and therefore there has to be a proper resentencing process, then this court will have to start by considering whether the death penalty is the appropriate sentence. It might be that you will reject it out of hand very quickly, but nevertheless it is something that is on the table. And it is therefore, although it is unlikely that the court will seriously consider imposing the death penalty in this case, it is nevertheless something that is before you. So it is not academic in the strict sense at all, because it is something that you will be required, at least in a sentence, to say, well, it is there, but it is inappropriate, and we go on to consider other matters. So respectfully, it is not an issue that is academic in this case, and certainly it is one that will arise.
It is academic in relation to these two appellants, these two applicants. It is not academic in the sense that succeeding persons who are exposed to the death penalty may be faced with these issues. But in relation to these two particular applicants, the determinations of law by the Court of Appeal, whether those determinations were right or erroneous, have not ultimately produced a result that can be characterized as, in relation to these applicants, a serious miscarriage of justice. How would you respond to that?
Well, in relation to these applicants, yes, the Court of Appeal has made a determination that the death penalty is not on the table. But in relation to them as well, they have determined that the death penalty is not unconstitutional. So again, I come back to the first point that I made, that ordinarily these applicants would be entitled to appeal on that constitutional issue. It has come before you by way of an application for leave, and the question now arises: is it academic? And it is, I suppose, regrettable that this is not an issue that was raised by the respondents, so that we haven't had an opportunity to develop the point in writing and referring to the court's previous jurisprudence on the issue as to whether a matter is academic. There is a case, a decision, I think it was a decision of Justice Anderson coming out of Belize, in a matter, it's a name that is unpronounceable, begins with an X, in which this court, again, the question of the appeal being academic was raised, and the court went on to determine it, even though in relation to those particular appellants, the determination of the issue would have made no difference one way or the other. But the court, I'm going from memory now, went on to make a finding that because the issue is likely to arise again, that it is one that the court would seek to determine. This is an issue as well. It is not a question that the court is not going to have all the material before it in order to make a determination, because there were full submissions before the court on both sides, in addition to expert evidence that we thought bore upon the issues. So the court will be fully assisted in the determination of the issue. The Attorney General as well appears anxious that the matter be determined finally at this level, having regard to the fact that he has not objected to the leave being granted on the issue. So I don't know if it is that at this stage, Your Honours, you would want further assistance on the academic point, with which we have not had the opportunity to develop further, or otherwise. Again, I'm just going on the basis of my memory of the decision of Justice Anderson.
President, if I may, I would inquire of Mr. Mendez whether it is his view that if there was to arise an occasion when the death penalty was imposed in Guyana, whether his view is that matter of the constitutionality of that penalty would in fact bubble up to the highest court. Do you have any doubt at all that in that sort of circumstance the issue would be transmitted to us through the usual process for consideration?
Well, it would be, but the way it would happen is that, first of all, there would be a challenge to the decision itself as to whether the death penalty was appropriate. So that it would be a question of sentencing principles in the first instance. And the question would arise again, if the matter came before the CCJ on the application of the sentencing principles, one might say, well, the question of the constitutionality of the death penalty is academic because on the basis of the sentencing principles, this is an inappropriate sentence and we're going to dismiss it on that basis. Or you might say, having regard to the flaws in the process that was followed by the High Court or the Court of Appeal, in, for example, not getting the necessary psychiatric evidence or evidence as to whether the person might be rehabilitated, etc. It has to be set aside and sent back. So again, the same arguments can arise. There is no chance that the appellant, that the death penalty will survive an appeal. So therefore, why go on to consider the constitutionality of the death penalty? My answer to that is that in all of those cases, the defendant, the accused, is being exposed to the possibility of a death sentence that might very well be unconstitutional in and of itself, and that the accused ought not to be exposed to it at all. Now, so if this court, I'm saying that the issue is right before the court because it was raised in the Court of Appeal, it was determined, and you have full submissions, and you will have full submissions on both sides. If the opportunity arises, then respectfully, it would not be the right thing to countenance a situation where somebody is convicted of murder tomorrow, a week from now, whenever, and then has to face the possibility of the imposition of the death sentence when that death sentence might be unconstitutional per se, and therefore consideration should not be given to it at all.
This is what I'm finding puzzling. If that were to occur, they have the typical example you just gave us, and somebody was convicted of murder and sentenced to the death penalty, why could the constitutionality of that sentence not be challenged then?
I'm saying that it could be.
Right, I thought you said that if that event occurred, then we'd have to look at the penalty on sentencing principles first.
Yes, but
exhaust that process. What I'm asking you is, why would it not be possible and feasible in the circumstance that you just described for the constitutionality of the penalty to be challenged in that case?
Well, there's nothing preventing it at all. What I was going on to say is that just as in this case, there was nothing preventing the constitutionality of the death penalty to be raised, I'm saying that in that hypothetical case that we are talking about, an appeal to the CCJ might be faced with the same arguments that Your Honor is putting forward, which is that isn't the constitutionality of the death penalty per se academic, because in any event the death penalty cannot survive a review on appeal having regard to the sentencing principles.
With respect, what we're talking about is a straight constitutional challenge to the death penalty, and that is being made by somebody who has been subject or has been sentenced to that penalty. So it's sort of not academic in relation to that individual, and with the constitutionality of the penalty, that is its way up through the Court of Appeal to the CCJ. To me, that is a qualitatively different circumstance from the one we have here, where our clients do not face any risk of being exposed to that penalty.
Well, Your Honor, with respect, the applicants always faced the risk of the death penalty. On conviction, they faced it. The High Court judge was wrong, as the Court of Appeal has found, to treat it as a mandatory sentence as opposed to a discretionary sentence. But if he did treat it as a discretionary sentence, the constitutionality of it as a sentence would arise. There was an appeal against that sentence, and on appeal, the argument that was, of course, as you would expect, the applicant's lawyers take every point that is available. And the first point that was taken was that the death penalty cannot be imposed at all, whether mandatorily or discretionary, because it is unconstitutional. The other string in the bow was, well, even if it is not unconstitutional, it is discretionary, because and the High Court judge was wrong to treat it as mandatory because the law had changed. In other words, he was wrong to say, well, it is mandatory because it was mandatory when the charge was laid. It was discretionary when the sentence was handed down. So that is the second string in the bow. We did not succeed on the first argument, which is that the death penalty is unconstitutional. We succeeded on the second argument, that it is discretionary, and therefore the court went on to sentence and all of the things that followed. So I'm saying that this case is no different to the hypothetical case that Your Honor is imagining, where the High Court judge correctly treats it as a discretionary sentence, and on appeal, the accused then wishes to raise the constitutionality of the death sentence. We are in the identical situation as that hypothetical situation, because the appellants have raised as their first argument that the death penalty is unconstitutional and ought not to be considered at all, whether mandatorily or in the discretion of the court.
Mr. Mendes,
so that issue continues to be live. I'm sorry, Your Honor.
Yeah, Mr. Mendes, it seems to me that it's not identical, because at the level of the Court of Appeal, the death penalty was there. It was on the table. It was imposed. And therefore, as you said, there were even three strings on the bow. First of all, you will make the point that the death penalty is per se unconstitutional. If not, then it's discretionary. And the third would be, well, if you have to choose, you have to choose the life sentence and not the death penalty for all kinds of reasons that were mentioned. Okay, so that happened. And so the difference is now that, as it is now, there is no imposed death penalty. That was the case before the Court of Appeal, but not before us. So it is a different situation. I understand everything that you are saying, but I just want to make the point that it's not completely the same situation as it was before the Court of Appeal.
Well, that is so because the Court of Appeal, on the alternative ground, had decided that the death penalty is not on the table. Mm-hmm. But it is possible that this court, theoretical, of course, that this court might take a different view of that. We don't know. I'm sure not. But I'm saying that the question whether the issue of the constitutionality of the death penalty is academic is not to be decided only on the basis that even if it was a penalty that is available, that the court would reject it out of hand. It is there, it is still hovering. And when the court comes to consider resentencing, it must, as a matter of law, as a matter of the determinations of this court, it must begin by considering what are the available penalties in law. You might reject a penalty out of hand for other reasons, but you must begin by considering what are those penalties in law. And as it stands, without considering the constitutionality of the death penalty, you will have to say, well, the one available penalty is death. And then we go on to consider whether to reject it. And as I say, you may do that in one sentence and without more, but you will have to start by accepting that it is available. And by accepting that it is available, you are implicitly sanctioning it. with having regard to the fact that it is a live issue before you know. You will be in effect sanctioning the Court of Appeal's decision that the death penalty is not constitutional.
No, with respect, I'm not sure if that's where we start. I guess said we start by considering or accepting the availability of the death penalty. I think we start by deciding whether we grant leave to appeal. It's an application for special leave, as I understand it. So we must be satisfied that there has been a serious miscarriage of justice. So I think we start first of all by deciding whether we consider that there has been a serious miscarriage of justice. If we were to be of the view that there was no serious miscarriage of justice, given the sentences, you're arguing sentencing, given the sentences imposed on your clients, then why would we need to go any further?
Well, Your Honor, I guess this comes down to the procedure that the applicants chose to follow. Because the applicants, it would appear to me, could have decided, well, we are going to apply under the Guyanese constitution for a determination that we have a right of appeal to the CCJ because it is a constitutional issue. If that had happened, then the Court of Appeal would presumably have recognized that there is a right of appeal on the constitutional issue and would have granted leave. And then this court...
But Mr. Mendes, what then would they be appealing, given that the death sentence was not imposed upon them?
Appealing the finding by the Court of Appeal that the death sentence is not unconstitutional and therefore is still available to be imposed upon the appellants as a matter of law.
No, but it wasn't imposed. It was ultimately not imposed upon them. In other words, are you permitted to argue on behalf of prospective murderers as distinct from on behalf of your clients?
Well, we are arguing on behalf of our clients because our clients were exposed to the death sentence wrongly because it was treated as mandatory. When it got to the Court of Appeal, they were in jeopardy of the death sentence being reimposed, but the Court of Appeal did not do so. But it was on the table, so they were in jeopardy. It was rejected, and this matter has now come before the Court of Appeal. Now, theoretically, because it is still a penalty available in law, it is still open to this court to reimpose it. Although, as I say, I would not expect that to be the case. So to say that it is academic, respectfully, it might be academic only in the sense that it is unlikely that this court would accede to a submission made on behalf of the Attorney General if he was to make it, that the death penalty was appropriate in these circumstances because this is a member of the defense force who ought not to have participated in these events and ought to have intervened, etc., etc. So that there is always the danger there, and therefore the appellants being in jeopardy from a legal point of view, that is to say that the penalty is on the law books and is available to be imposed, they are entitled to ask this court, take it off the books altogether. And when you come to the question of sentencing, the only available options ought to be life imprisonment. In other words, you ought not to have at the back of your mind, well, you got away from the death penalty, and therefore that might subliminally influence the court as to the term of imprisonment that might be imposed. Whereas we are submitting that ought not to be on the table at all, and therefore ought not to subconsciously affect the court in determining, for example, well, is this term of imprisonment adequate, having regard to the fact that the person escaped the death penalty, for whatever reason that they escaped the death penalty. So the applicants are entitled, just as any applicant in the future is entitled, to ask the court to make a determination on the constitutionality of the death penalty.
Okay. Is there anything else in relation to your application for special leave?
No, Your Honors. Again, we rely on the submissions as insofar as the merits of the argument. But as I say, I would have preferred an opportunity to address the court more fully in light of the court's own jurisprudence on whether an appeal is academic or not.
Do you want to tell us the broad outlines of that argument in 5 or 10 minutes at most?
Well, without having the principles that the court had set out in the case that had been referred to before me, basically that is what I would be doing, relating what I have just said to those principles. I don't think that I'd be saying anything very much different from what I would have already said, but certainly I would be relating it to the principles that this court has established in order to determine whether an appeal is academic or not.
Okay, I understand. Is there anything from my colleagues? Anything further before we hear from the DPP?
No, thank you.
No, yes? Okay. Yeah, well, thank you very much, Mr. Mendez.
Of course, Your Honors, I haven't addressed the other aspect of the case, which is the process that the court followed in sentencing. But of course, we also seek leave in that regard.
On that issue, yes, and we have those submissions in hand, and that's a very straightforward point which we understand. Yes, well, thank you very much, Mr. Mendez. Ms. McCallan, are you going to respond to us?
Yes, please, Your Honor.
Yes.
Your Honor, the prosecution's case against the applicant Greenidge has always been and is on the basis of circumstantial evidence, as well as the caution statement that was given to the police place by the applicant Greenidge. The state also relied on two concepts or principles in law known as joint enterprise and the felony murder principle, please, Your Honor. It is the state's submission that the applicant Greenidge shared the common intention, please, or there was a plan to commit the felony of violence, the violent felony of robbery, please. That he was part and parcel of a joint enterprise to rob the deceased Kant Ramdas. That can be drawn, please, from the circumstantial evidence relied on by the state, as well as the caution statement given to the police. Your Honor, the circumstantial evidence in relation to the applicant Greenidge is as follows. The applicant Greenidge, along with the two other appellants, would have approached or was seen approaching the deceased, who was sitting on the beach with his cartoon box that contained $17 million, please.
Sorry, go out again. You said Greenidge would have seen him approaching the boat?
No, he was seen. Greenidge was seen by the witness Tucker, or Leonard Bonson called Tucker. He was seen approaching the deceased in company with the other two appellants. Greenidge, along with the other two appellants, would have spoken to the deceased for about 4 to 5 minutes, according to the evidence.
Greenidge was part of the group that spoke with the deceased?
Yes, please, Your Honor.
Yes.
And that was witnessed by brother's son, is it?
Yes, please, Your Honor. Leonard
Okay.
Paul Tucker. The evidence for the prosecution, please, is that Greenidge at the time was also armed with a rifle. They spoke to the deceased about 4 or 5 minutes, and then they were seen escorting the deceased to the Coast Guard boat. Robertson became concerned because of the facial expression, please, of the deceased. And as a result, he would have contacted the brother of the deceased to relay what he had just seen transpired. Your Honor, Greenidge, in his caution statement, would have stated that he was told that they were giving this deceased a drop to Bonesico, which is an area in the Essequibo Island, please. Essequibo. And that...
Counsel, was that statement recorded in any way?
Yes, please, Your Honor. There was a written caution statement that was tendered in the High Court. However, please, Your Honor, the respondent take it upon themselves to have that statement relayed, or scanned and relayed to the court, please. I regret that it was not done before, and we will endeavor to have that statement sent to the court, please.
So it was recorded in writing, was it?
Yes, please, Your Honor. It was recorded.
Was it recorded in any other way?
No, please, Your Honor.
I gather that there was some dispute at some point about the voluntariness of the caution statement. Was that it?
There was a voir dire, and it was held to be deemed fully and voluntarily given, please. There was objection to that statement, and the trial judge would have held a voir dire, and the trial judge would have ruled that he found that statement freely and voluntarily given, and it was admitted into evidence.
I understand. Just to make the point that it may be useful to consider whether there are other means of recording the caution statements which are not susceptible to the kinds of allegations made by the accused persons. And in particular, recording using audio or video devices might be helpful, because in those instances we may not need to resort to voir dires. And I think this court has made that point several times in the past, just an indication perhaps of where we are. If the technology is there and can avoid us lengthening these processes by having voir dires and so on, why do we need to do that? So I don't know where we are in the DPP's office, but it seems to me that to the extent we can use technology to avoid issues of voluntariness and so on, we should do that.
Yes, please, Your Honor. Your Honor, the respondent submits that that technology is available now, but at the time of the trial, please, in 2013, such a technology was not available to the court, please.
Oh, that's good news. You say it's available. Is it being used now?
It's being used now, please, Your Honor. Yes, please.
Oh, wonderful. Wonderful. Thank you.
If I may proceed, please, Your Honor.
Yes, please go ahead. You said Robertson was concerned about the facial expression of the deceased. Yes?
Yes, please, Your Honor. And the applicant Greenidge in that written caution statement would have indicated that he was told or he was informed when they would have met the deceased on the beach that they were giving him a drop to a place known as Bonesico. However, please, Your Honor, when that deceased went onto the boat, that boat was stopped in the river before reaching Bonesico, and the deceased box that he had with him containing that $17 million was searched. It is the applicant's Greenidge contention that he was told or he was asked to search that box to see if it had contained money. And as a result, he did so, and he opened the box, he saw that it contained money, and he would have relayed this information to whom he was asked. He then submitted, please, stated in that statement that he then saw or he heard the person, the deceased, thrown overboard. It is the state's contention, please, Your Honor, that Greenidge at the time when the deceased was thrown overboard made no objection. He did nothing to show that he was not a part of the unlawful search of the box, in that when he was allegedly told, according to him based on his statement, that he should open the box to see if it contained money, he having said that he was told that they were giving this deceased a drop to money seeker, willingly participated in opening that box. And the state is saying that at that moment, the circumstances gave rise to there being more than the deceased being placed on the boat as to merely giving him a drop. And the state is contending that in those circumstances, it can be inferred that there was an intention to rob this deceased, and that the applicant Greenidge was a part of that shared intention to rob the deceased. As I would have indicated before, he was allegedly told that they were giving this man a drop to Bonisico, but when the boat was stopped, he nevertheless participated without objection to the searching of his box. When the deceased was thrown overboard, even though it was not by him, he, though armed with a rifle, did nothing to stop or prevent the deceased from being thrown overboard. Now, even in the circumstance in the river, there wasn't much that he could have done to prevent the deceased from being thrown overboard. When they would have returned to Fort Island and the money, please, was divided amongst themselves into 3 parcels, he at that moment nevertheless did nothing again to show that he was actively or that he was even withdrawing from that shared intention the state is contending to rob this deceased. It is the respondent's submission that if Greenidge was not a part and party of the robbery, he could have shown that he was dissociating, that he was withdrawing when he had the first opportunity. That is when they would have returned to Fort Island. He did nothing. They then left Fort Island having divided the money, and they would have returned to Puerto Rico. Even at that stage,
Counsel, I would love to come back to the point you're at now about dividing up the money, but I'm still very curious about this. So on the boat, when there was a crime that was committed,
yes,
and throwing this gentleman overboard clearly is a crime, and robbing him of his $17 million equally so. As a law enforcement officer, what is the responsibility of Mr. Greenidge? You say he had a long gun. A crime is being committed. Does he have any enhanced responsibility to do anything in those circumstances? Or is the responsibility the same as that of an ordinary citizen? What do you make of it? I'm very curious.
No, please, Your Honor. His responsibility is not the same as an ordinary civilian, please. He, as a law-abiding citizen, could have done something as a law enforcement officer, could have done something and should have done something to show that he was not a party to what was being, what was taking place on that boat. And he did nothing.
But you have what Mr. Hughes said. Mr. Hughes said that he was a junior officer and basically taking orders from a superior officer. So are you saying that junior officer in those circumstances was entitled to, was obliged to disobey the orders of his superior?
It was not part of their duty. This Okay. Yes, please, Your Honor. In the circumstances, the respondent is submitting that he should have and he could have disobeyed the orders of his superior. This was not part of their duty, please, Your Honor. This was a crime about to be committed, and as a officer, please, of the GDF, of the Guyana Defense Force, a military officer, he should have done something and ought to have done something to prevent that crime from taking place, please, Your Honor. He was not a civilian. He was not an ordinary civilian, and he could not be, it could not be the same for him, please, Your Honor, as a military officer.
I'm going to ask, is there any connection at all with the law of court-martial here? Is there any relevance of that regime?
Your Honor, it is the respondent's submission that if the DPP's chambers had not charged or had not recommended criminal proceedings, then in those circumstances, a court-martial may have been something that could have been considered, please.
And it's not work relevant. It's what Mr. Mendez would say is academic, no doubt. But do you have any idea as to what the penalties would be if there was a court-martial in this situation? You may not, I don't know, I'm just asking.
Yes, Mr. Runner, there is no murder under the Defense Act, so it would not have been a criminal penalty, but he could have been struck off, please.
So the application of martial law in the circumstance, at most, would have resulted in his being struck off. Is that what you're saying?
There is no provision for murder. There is provision for other offenses, but not for murder, please.
So, exactly. So in this circumstance, the maximum penalty would be that he'd be struck off the list of enrolled officers, I imagine.
Yes, please, Your Honor.
Sounds a little strange to me, but there you are. Thank you. I'm sorry I interrupted. I think you had a point of the division of the money.
Yes, Mr. Honor, it is the respondent's submission that Greenidge was a party to the plan, please, to rob this deceased, and that he had the intention, not only, and that intention, or his part, was not only when he would have seen the accused being thrown overboard, but it is the respondent's contention that from the inception, based on the circumstances, that Greenidge was a party to a joint enterprise to rob the deceased. And as I would have outlined before, that is based on him approaching the deceased, armed with a firearm, speaking to the deceased, escorting him onto the boat, having been told to search the box to see if that box contained money. He willingly participated without objection. And it's the state contention that if he was not a party to that shared intention to rob this deceased, then he ought to have objected, being that he was a military officer more so. He ought to have shown that he was disapproving of what was taking place and what was about to take place. Your Honor.
It seems to me that, as is usual, these are very serious cases, but the evidence is, as usual, minimalistic, if I may say so. I'm not saying it's not enough. That is a question that needs to be answered. But if it is enough, it is really minimal. You were saying that, based on the circumstances, and you mentioned that Mr. Greenidge had a gun with him. But isn't that a normal thing for a military officer to have a gun?
Yes, please, Your Honor. It is normal for a military officer to have a gun, but separate and apart from him being armed with a gun, please, Your Honor, he did nothing. He voiced no disapproval, please. And
is that something we know from the evidence, or is that something we have to assume by lack of evidence? Well, I know there is evidence that Mr. Ramdas, was thrown overboard in the middle of that river. Do you have any evidence of what happened after that? Or is it simply something that we have to assume that nobody tried to rescue him, etc.?
In the evidence, in the written caution statement, please, of Greenidge, he was saying that after the deceased was thrown overboard, he did not check to see if the deceased could swim, please, and that they then went back to Fort Island, leaving that man there. And
okay, well, that's why we would like to see the caution statement, because that seems to be the centerpiece of the evidence in this case. But in order to see if that is so, we really would need to see that caution statement. As I mentioned, there were, of course, other caution statements of the two others who were more clearly in saying that there was a plan to kill Ramdas. Isn't that so?
Yes, please, Your Honor.
Yes, but of course those statements couldn't be used against Greenidge,
Yes, please,
at least not in the state of the evidence law as it is now.
Yes,
So, and I understand the trial judge told that to the jury. Of course, the jury must have heard it. But anyway, but in the statement of Greenidge, you're saying that after the man was thrown overboard, he decided not, or he didn't do anything to rescue him. Is that what is in his statement?
yes, please, Your Honor. He did not. He didn't check to see if the man could have even swum.
Okay, well, that is information that is useful to have. So would you say that the evidence was mainly based on as far as you can see it, because of course what the jury thought will be always a mystery for all of us, but the witness statement as you see it is the main evidence in the case against Greenidge? Maybe isn't that so?
No, please, Your Honor. All there is the written caution statement. It is the response. It has been the prosecution's case always, and as the trial judge would have directed, that the prosecution always relied on the circumstantial evidence together with the caution statement of the applicants, please. And those directions were given to the jury. The circumstantial evidence relied on by the prosecution, as well as the caution statement.
Okay, now, and the circumstantial evidence was that the officers approached Mr. Ramdas while he was sitting on the beach, that they talked to him, that they went with him to the boat, that his facial expression at some point changed, which made one of the witnesses quite worried, so worried that he called the brother of Mr. Ramdas. I think there was even, did the brother not call Mr. Ramdas while he was on the boat?
Yes, please, Your Honor. The current chance, that is the person, the witness who had given the 17 million, please, to Ramdas. He would have tried calling him, as is customary, several times. He would have spoken to him twice, but then he could not have gotten through to him, and he too became concerned. So having returned to Georgetown from Puerto Rico, he would have informed his boss as to what took place, that he's trying to get the deceased and he's unable to do so. As a result, he went back to Puerto Rico, and he would have also spoken to Brodesman, who would have informed him of the situation, and as a result, they tried calling the applicants.
Yes, but surely you would agree that on the basis of the circumstantial evidence alone, without the caution statement, you would not have a case.
The respondent does respectfully disagrees, please, Your Honor.
You would even base on that circumstantial evidence of felony murder? If you had no other evidence, because the evidence is the circumstantial evidence and the caution statement. I would think that if you only would base it on the circumstantial evidence, that would require a lot of speculation. I thought that you got the evidence which you rely on would be the combination of the caution statement and the circumstantial evidence as we just set out. Isn't that so?
Yes, it's a combination of both, please, Your Honor, the circumstantial evidence and the caution statement as stated.
Yeah.
Yes.
Okay, well, thank you very much.
Yes, anything further on the conviction?
Yes, please, Your Honor. That's it, please, Your Honor, for the conviction.
Okay, now would you address, are you, as you were confused at the outset, is the DPP conceding the ground of the application that relates to the sentence, or is it only the Attorney General's chambers?
Your Honor. Your Honor, the Attorney General, while dealing with the constitutional aspect of the death penalty, paragraph 53, please, of the respondent's submission, the respondent submits that the sentence of the applicants by the Court of Appeal is life imprisonment, and the death penalty was not the final decision of the Court of Appeal. Therefore, the issue of the constitutionality of the death penalty does not affect the applicants, and it ought not to be appealed by them, since this was not the sentence of the Court of Appeal. And that is the respondent's submissions, please.
I see. So that you are not supporting the on either ground, whether on the conviction or on the sentencing, are you supporting the application for leave to appeal? Is that correct?
Yes, please. Yes, please, Your Honor. That is correct.
Okay, well, let me just ask you this. Assuming, because the applicants are saying that the Court of Appeal has produced a judgment, an oral judgment, that creates a bad precedent, because it states that the death penalty is not saved, or that it is saved rather, and that in their view, the death penalty per se is unconstitutional. The Court of Appeal denies that. If the Court of Appeal is wrong in those respects, should that precedent be left on the record?
No, please, Your Honor.
Okay, well, let me ask a follow-up question. Given that the applicants are suggesting that this court, in these proceedings, should examine the arguments that suggest that that's a bad precedent to be left on the record, and hopefully, as far as the applicants are concerned, set that precedent right. Why shouldn't the Court of Appeal, shouldn't this court give leave to appeal so that that can be developed and argued?
Your Honor, it is the respondent's submission that the precedent was not a bad precedent set by the Court of Appeal, in that our Constitution, Article 138(1), would have stated that no person shall be deprived of his life intentionally, save in execution of the sentence of a court in respect of an offence under the law of Guyana of which he has been convicted. So our constitution, please, Your Honor, provides for the death penalty. So it is the respondent's case that the Court of Appeal was not wrong in that precedent in stating that it was safe law and that it was constitutional.
I see. Is there anything else that you wish to say to us on this aspect of the case?
Sorry, I think you went off. You're muted, and you're muted now, so we didn't hear your answer to the President's question.
No, please, Your Honor.
Yes, there's something I wanted to ask you though. Are you asking this court for an enhancement of the penalty imposed on any of the applicants?
No, please, Your Honor. We think that the penalty is consistent with what the CCJ has given place.
And you typically not asking this court to impose the death penalty, are you?
No, please, Your Honor.
Okay, thank you.
Okay, thank you very much.
Can I ask one more question, President? It was said that if this had been accessory after the fact, it would carry exactly the same sentence. Could you confirm that?
Yes, please, Your Honor. Yes.
So it would be, even if it's accessory after the fact, the punishment could be as death penalty or a life sentence.
Tried, convicted, and sentenced.
No, please, Your Honor. It would have been life imprisonment if he was convicted as an accessory after the fact, as stated by Section 105 of our Criminal Law Offences Act, Chapter 801.
Okay, so would that be a mandatory life sentence or would that be the maximum sentence?
Maximum sentence, please.
Okay, so it could be lower then.
Yes, please, Your Honor.
Okay, thank you very much.
Okay, thank you. Mr. Mendes, is there anything that you wish to say in response?
Your Honor, while my learned friends were submitting, Mr. Middleton sent me the authority that I was mentioning earlier on, and there are a couple of paragraphs. That is the Yakchi case coming out of Belize. Would it be okay if I just share screen those paragraphs of the decision?
Sure, go ahead.
Is it up? I'm not sure if it is.
It's not up as yet.
Maybe I hope I'm doing it correctly.
It's coming up now. Yes.
Yes, Your Honor. This is a decision of Justice Anderson. I think, Your Honor, you were also on the panel. And Justice Anderson says the question arises as to whether this court can hear academic appeals, and if so, in what circumstances and subject to what conditions should it do so. And then Justice Anderson went on to look at the provision dealing with applications for leave, and he continued, notwithstanding this broad competence to entertain any appeal, it is an important feature of our judicial system that the court decides disputes between the parties before it and does not pronounce on abstract or hypothetical questions of law where there is no dispute to be resolved. In general, there must exist between the parties a matter in actual dispute or controversy which this court can decide as a live issue. Of course, the submission that we have made is that the question of the constitutionality of the death penalty is still a live issue, at least as between the applicants and the Attorney General, who also wishes it to be determined. But Justice Anderson went on to say this. However, there is not an absolute rule that bars the hearing of a matter, even if the by the time the appeal reaches the court, there is no longer a live issue between the parties. Several Caribbean courts have accepted that an academic appeal may be heard if it raises an issue of public interest involving a distinct and discrete point of statutory interpretation, which has arisen in the past and may arise again in the future, with circumstances approximate to those in which a final court should exercise its discretion to entertain an academic appeal as discussed in the House of Lords in those decisions that are then cited. And then he goes on here. For the reasons given at 3, we agree that this court should be cautious in the exercise of its discretion to entertain an academic appeal and should in principle only do so where the question is one of public law that's distinct from private law, rights dispute between parties, and where there are good reasons in the public interest to hear such an appeal. We agree with Lord Slynn of Hadley, who in delivering judgment in ex parte salem stated that an appropriate circumstance for an academic appeal when where the appeal raises a discrete point of statutory interpretation of the powers of a public authority without need for detailed consideration of factual situation, especially where the issue is likely to arise again for resolution in the future. And then he says, another indication of appropriate circumstance may be where the issue is a recurrent one that is likely to become moot before it reaches the ultimate court of appeal. And he goes on to give other examples. So, Your Honor, we're respectfully submitting that I'm not too sure how to discontinue sharing.
Let's X the button.
I think I got it.
With the red button. Yeah.
Yes. So that, of course, this falls within those words of Justice Anderson. This is a public law issue. It is a discrete point of law as to exactly what the Constitution provides. It doesn't require a resolution of fact. And of course, it is one that is likely to arise, as the discussion that we've been having earlier on indicates. But it is a matter that if somebody is convicted of murder and is sentenced to death, then that is an issue that is likely to come back before the CCJ. But it is in the public interest as well. I would respectfully submit that it be resolved, because if it is the case, contrary to my learned friend's submission, that the Court of Appeal is wrong and the death penalty is unconstitutional, then we respectfully submit that it is not in the public interest that anyone from now on, from henceforth, should be exposed to the possibility of an unconstitutional penalty, more so the death penalty, being imposed upon them. It is an issue that is likely to arise in the future, and therefore, from that point of view, respectfully submit. It is one that the court ought to deal with now rather than later. Even if the court is of the view that it is academic in this appeal, in the sense that, as the DPP has just said, they will not be asking the court to impose it. So that on the learning as coming out from the case of the ACG, we respectfully submit that this case is a prime candidate. As a matter of fact, I can't think of very many other cases which would not fit the description of the type of case that the court ought to hear, even if it is determined that it is, strictly speaking, academic. And I emphasize again that it would be, it would not be right that the court would allow someone else to be exposed to the death penalty when there's the chance that this court might hold it to be unconstitutional.
Yes, thank you. Mr. Hughes, is there anything that you wish to say?
President, maybe before Mr. Hughes, I see the Solicitor General present. They did not file written submissions, but maybe we could give them leave if they want to say something on this point of the death penalty, that they have that opportunity.
Your Honor's majority, I think we intimated to the court and to our learned friends that we had no objections to leave, because we think indeed this is a point of law that has should have some consideration by our apex court, this honor court. So in that respect, on the constitutional aspect, we certainly think that it is something that should be at least canvassed before your honors. Not as much as say with your leave at this point. Oblige.
Yes, thank you. Mr. Hughes?
May it please, Your Honor, just a very narrow point in relation to questions from His Honor Justice Anderson, which is that Mr. Greenidge was not a law enforcement agent at all. He was a military officer and part of the Coast Guard. So the obligations of a police officer, for example, who sees a superior police officer commit a criminal offense, he has enhanced obligations. But a military officer, in these circumstances, in my respectful submission, it's a different set of rules that apply. So I don't think, I think that is a distinction that ought to be borne in mind. Let me not say more than that. That's all I would like to say in relation to what was said.
Okay, thank you. Okay, we are going to reserve our decision on this matter, but we do need to see that caution statement, and which of you will be sending it to us soonest?
The DPP's chambers would undertake to have it sent to the please, Your Honor.
Is it three statements that will be sent?
Yes, please, Your Honor.
I think Your Honor means the statements of the three accused persons at the Court of Appeal level.
That's correct.
Yes.
Yes. Okay, so I want to thank Counsel for your submissions, both oral and those that were previously sent in writing. As I said earlier, we would reserve our decision, and we would also await the statements, the caution statements that were taken from the three accused who were prosecuted. So thank you very much, and Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day. Thank you.